Choice of business entity. When you want to start a business, you have many options. But what are the things you should keep in mind? So as we can see here in choice of business entity, what is the selection criteria? So if you see here, the first thing is the objects of the business. That is, what is your business for? Is it software business? Is it retail business? Is it just consultancy? Or is it manufacturing company? So these are the things you should think before you start the business. So before that, you tell me, what are the different kinds of business entities? Yes, you know very well, proprietorship, partnership, private company, LLP, public company, correct? These are the forms of business. But before you start, what should be in the mind of you who is the business entrepreneur, the founder before you start? So these are the points. Then the number of members. So how many people you require? For example, private company, we just need 2 people. But for public company, we need 7 people to start that public company. Then the next question is amount to be invested. How much should we invest? What kind of business we need? Is there any risk involved, etc. Then the fourth point is relating to the operations. The scale of operations. Are you going to have business only in one city? Are you going to have in multiple locations? You're going to have corporate office, then again factory, etc. So depending on your scale of operations. Are you going to have international transactions? Are you going to have international business? These things you must consider. Going further, what is the state control? That means how much control does the government have over your company? If you are a listed company, there is extreme control by the state or what we call as the government because the compliances are very huge. But if you are a proprietorship concern, the control is very less. It is as good as individual person. You are sitting at home and doing whatever you want. The control is much lesser. Then the next and important thing for big businesses is tax implications. Tax implications can determine on what kind of business you want. So for corporations, that is private limited company, public company, the taxation is 25%. But for LLP, the taxation is 30%. So this will also become an important factor depending on what is your kind of business. Then you can think, should I start company? Should I start LLP, etc. Then the next point is legal requirements. Again, like I told you, if you are public company, listed company, you have multiple legal requirements. But if you are a simple proprietorship or partnership, your documentation legal requirement is very, very less. Then what is the competitive advantage which you are going to have compared to the other forms of business? So these are the things which you should keep in mind when you are starting a business. Now that you know that, we can go to the next concept, the forms of business. Most of it you may already know, but let us try and understand here. So if you see here, we have the forms of business enterprises. So what are the forms of business enterprises? The first one is non-corporate form. Non-corporate form, we have first sole proprietorship concern. So sole proprietorship concern is a business where there is just one person. So you yourself can start the business and run the business. As the name goes, sole proprietorship concern, there is just one person. That you know very well. Then the second one is partnership. You only tell me in partnership how many people we need. Minimum is two. The very name partnership means you need at least one partner to call yourself a partnership. So the partnership is the second form of business entity. So what are the features of a partnership? The features of a partnership, the first point is contractual relationship. So if you say Indian Contract Act, it says what is a contract? A contract is basically an agreement which is enforceable by law. So when do we have an agreement? When there is consensus ad idem, that is meeting of two minds. There are two people who agree upon something in the same sense, in the same time, for a particular consideration, we say there is a contract. Yes. Similarly, in company law, whenever there is a contractual relationship, we can say that there is a partnership which is emerged. So for partnership, which is the act? Indian Partnership Act 1932. Then existence of a business and partnership. Then there is sharing of profits. then there is mutual agency. But what is the biggest problem in partnership? Unlimited liability. Liability is unlimited. Why is the liability unlimited? Because partnership is not a separate entity in the eyes of law. So if you are in a partnership, you have many flexibility advantages, but the biggest disadvantage is unlimited liability. So if you are a partner and there is some problem in the business, even your personal assets, your personal house, your car, your scooter, even that can be attached by the court, because in the eyes of law, the partner and the partnership firm is one and the same person. So this is very important for you to understand. Then we have the joint Hindu family business, or what we also call as HUF. So Hindu undivided family business is unique to India, and in the Hindu tradition there have been businesses where it is managed by the Karta. This you already studied in your plus 2 or any other BCom etc. Now we will go to the limited liability partnership. So we have a separate chapter, limited liability partnership. We will be studying it in great detail. But now for you to understand in simple words, a limited liability partnership is exactly like a partnership, but as the name goes, the liability of the partners is limited to the extent of their contribution. So personal assets of partners will never be attached in LLP. As the name goes, limited liability partnership firm. So limited liability partnership firm is basically under the LLP Act of 2008. So LLP Act of 2008 talks about limited liability partnership firm. Then if you go to the corporate form of entity, we have corporate society organization, and then we have company. So in company, we have public company, private company, and one person company. So what is each one of them, we will be understanding in detail. Now we will come to incorporation of a company. What are the prerequisites for incorporation of a company? So here please understand the existence of company law as per the Companies Act of 2013. So we have to incorporate a company under Companies Act 2013. So if you see over here, in common, a company is a legal entity different from its member and has perpetual succession. So what does it mean? Company and the person who start the company are separate in the eyes of law. If you see Solomon versus Solomon case, we say that the person who started the company and the company are separate individuals, and that is why it is a concept of separate legal entity. Same way in the case of Lee versus Lee's air farming, we already studied that it is a concept where the person and the director and the owner can all be the same person at the same time because of the magic of corporate personality or artificial juridical person. Now, what is the important things relating to incorporation? So if you see over here, we have section number 3. So section 3 of the act is related to incorporation. So here if you see that the company should be started for a lawful purpose or association. You cannot have an illegal company. You cannot have a company which says, okay, we are only going to steal people, we are going to do theft. That company is not valid. Then, who are the promoters? The promoters should be at least 7 members in public company, at least 2 members in private company, and minimum and maximum 1 member in one person company. So in one person company we can have minimum 1, maximum 1 member. Directors we can have how many ever, just like other companies, but member shareholder is only 1. And in the private company it is 2 and public company it is 7. It is common sense, you have to remember in a very easy manner. Then going for the subscription of the names to the MOA. So the persons who are going to start the company should subscribe. What is subscription? Subscription is basically an agreement which is you are telling to the company that I undertake to subscribe the shares of the company after the company is incorporated. So once you subscribe, that means the shares will be allotted to you after the incorporation. So subscription is before incorporation, where you are agreeing to take the shares after incorporation. So after incorporation, you must pay whatever is the money for the shares, and then the shares will be allotted to you as per the provisions of the act. Then going further here, the compliance of legal requirements of the act. So you must comply the different requirements like filing Spice 32, all the forms, filing the PAN card, the Aadhaar card, all these documents have to be filed. And once everything is filed, then we can say that the company is incorporated. So I hope you understood this slide. Who is a promoter? Who is a promoter? This is told in section 2 subsection 69 of the Companies Act of 2013. So here what we should understand is, in this particular provision, this is applicable for many sections, so please concentrate and understand this provision very simply. Okay, so who has been referred as such in the documents? What documents? In the prospectus. So in the prospectus of the company, if we call somebody as promoter, that person will become the promoter of company. And the second thing is, if is identified by the company in its annual return. So in as per section 92, we file annual return to the ROC in MGT 7, correct? So in MGT 7, whoever we show as promoter is called promoter as per section 2 subsection 69, which is definition of promoter. Then the second thing is very important, which they have widened the definition of promoter in Companies Act 2013. So if you see here, the person who has control over the affairs of the company directly or indirectly, they're saying directly or indirectly. Anybody who is having control of company directly or indirectly will become promoter. Okay. So how he can be directly or indirectly? One, by way of shareholding. Two, by weighing of director. So now let us take a imaginary example. So if there is a person, Sachin Tendulkar, who is invested money in a company, but through his friend, it is not him, through his friend he has invested. So at that time, indirectly, Sachin Tendulkar will become promoter of the company, because if you see here, who has control over the affairs of the company either directly or indirectly. So Sachin Tendulkar has control how? Indirectly over the company. So that is very important by way of shareholding. Yes. Then the other way to become promoter is whose direction, instruction or advice the board of the company is accustomed to act. So this is a very important change in the Companies Act 2013, because there were many companies which was funded by terrorist organizations. There were many companies where we don't know who is the real owner, and this is a national security issue. It will become a very big problem if people are using companies to do all illegal activities in India. So that is why they have added this provision which says a promoter is a person in whose direction, instruction or advice the board is accustomed to act. So let me take an example. Now we have the great Don Dawood Ibrahim. He is sitting in Pakistan. So when Dawood Ibrahim is in Pakistan and he has some control over some companies in India by way of money laundering, he has given money in other way, etc. So in such a circumstance, what happens is that he will also be called as promoter. So you may ask me, so what if he is called promoter? What is the use? The use is that every promoter is personally liable. Every promoter is personally liable. But in the old Companies Act, there is no such provision. But in this act, they're saying that even a person under whose directions, control the board is accustomed to act. So Dawood Ibrahim is sitting in Pakistan, and the board of the company here in India is listening to whatever he says. Though Dawood Ibrahim's name is not in paper in the company, he is not shareholder, he is not director anything. According to this definition, even he becomes a promoter under the Companies Act, and he will be personally liable suppose he gets caught in any scam or any other fraud, etc. Yes. So this comes to the conclusion of this particular concept.